Hello, everybody. Your Honor, I need to say hello. Ava and I decided to debut our Halloween costumes just a tad early. I bet you can never guess what we are. Hello, Jenny. Okay. I know I promised you that I would give you a treat if you put up with the hat for a minute. You're such a good girl. Oh, how y'all doing tonight? Hello, Nana Laura. Hello, Auntie M. Hello, Mortimer Duke. Oh, I don't know if she will tolerate these, but this came with the costume. Can you show all of our friends, Ava? Ava, come on. Show them. Oh, I love it. Okay, I know you're not as big of a fan of it as I am. Oh, she's like, lady, that was only one treat. That's just a little nibble of one. That's not even a whole biscuit. Hello, Joey Bag of Donuts. Hello, Lizette Panette. Hello, Sobe Liz. Oh, okay. My goodness. Oh, here, let me fix your badge. Will you at least keep the badge on? She joined the police. Hello, Esquire. I love you. Hello, Brian Boggs. Hello, Tiana Miller. Hey, Shane. How you doing, buddy? Oh, hello, Sir Philip. And hello, Russell, even though you're taking away my sweet Philip. A liter of cola? No. I know exactly what you mean. Yeah, you. Oh. I love you, Sherry B. I'm going to wave at you anyways. Hello, Sherry B. I love you so much. See, Esquire does too. Hey, now. Okay, fine. Actually, let's see. She's had 2 and a little tiny corner. Oh, hi. Don't worry, kitty treats are coming. My goodness. You want to hear something funny? So I was on the phone with my lawyer from my accident case today, and Esquire was clawing at the bathroom window screen. And so my lawyer's talking, and all of a sudden I'm going, Esquire, no! Esquire, no! He's like, what? I go, oh crap, you're an actual lawyer. You might find that a bit odd. So then I texted the law firm pictures of Esquire and explained, hey, this is what happened. This is Esquire. And I sent the PAWFURM logo. They thought it was super cute. Yes. I'm happy to be home. I did, so a lot of you know my father was he was a community service officer for 36 years. And so I've talked about the patches collection campaign that I did for him before he had to medically retire. And with everything going on with my father's health and with the recent passing of my mother, he's telling all of the kids, get your stuff, get your stuff out of the house. And he told me, he's like, if you want those patch boards, you can have them. So they've kind of, some of the patches have fallen off in transfer, but I have to redo a couple of the boards entirely. But I have the 6 patch boards that I made for my father. And then I have also I have a whole box also of other patches. I'm so grateful. My neighbor carried all of these in for me. And he did something else really cool for me that I'm going to show you in just a moment. This is this one. This is my father's department. Let's move Esquire. This is the old patch. And then this is the newer one. So I had the 2 patches from his department on here. And then, so I had to come home and feed the cats yesterday. And, cause they need to eat. And when I came back, as I pulled into my driveway, there was a brand new walker. So my old walker was really heavy. It was so hard. It didn't fold up much. I came home and this super lightweight, absolutely beautiful walker was just sitting in my driveway. And so I texted my neighbor and I'm like, did you see anybody at my house? I'm like, somebody left this walker, and I should have recorded myself. I wish I had dash cam or something, because as I'm pulling up, I see it and I'm like, that's a new walker. That's a new walker. Oh my God, that's a new walker. And I'm like screaming because you have no idea the horrible trouble I had with my old one, getting it into the car by myself. I couldn't do it. It was so hard. I did it, but it sucked. And to come home to a brand new walker. And so I texted him asking him, do you know anything? He's like, it was me. I couldn't believe it. I could not believe it. I am so over the moon grateful. And he's like, I didn't know if it would be offensive, so I didn't want to put my name on it. So I just figured I'd leave it there. I'm like, offensive? Oh my God, no. I'm so happy. So yeah, I am just, oh my gosh. I'm amazed. I'm amazed. Oh, thank you, Joey. Joey Bag of Donuts, you are awesome. Thank you so much. Hi, Linda Applegate. Welcome. Oh, I'm having just the best absolute. I am so grateful for all of you. Oh my gosh, I can't even put it into words. Okay. And I didn't want to say anything without Catherine Gaston's permission, but she has sent me a couple of emails with some pictures. She is losing her eyesight. I know. Aw, that's what I said too. She can barely see as it is now, so she's having a really hard time reading chat. I know there are programs made for people who are blind to be able to hear the commentary and things like that. I know it would be a lot to adjust to. I wish I had instant answers and solutions, but I hope you know how much we all love you. I'm serious. Like, and it breaks my heart to hear that you're going through that. It really does. Because you are such an amazing person. You have been so funny and so informative. You're so intelligent and you always look stuff up for us. And we love you. We absolutely love you. And that's actually, that's, you know, what I know. I'm sorry. Hello, Castro 42. I wish there was something that I could offer to, you know, to make it better right now, but have faith. And Billy, I'm sorry, you can't sit on the keyboard. You gotta at least let me move the keyboard out of the way, buddy. And I promise you will have food coming, you crabby old man. So, Catherine Gaston, I love you. And you need to know that. But you can always listen. And I really hope you're able to find something. All right, guys. So the other thing that I wanted to show that I was super excited about. I know, sweetie. Hey, Billy. I know you want your food. Oh, happy early birthday, Sobe Liz. I can try. It's really hard sometimes to be able to do that, and I can't stop the live stream to do that. But like right now, I can say that Cheney says that I can read the chats to you that you're tagged in, but Catherine, we are with you. And I think they're saying keep praying because they got the prayer hands. Emily is suggesting that you join the Discord and voice chat with us. Ginny, oh my gosh. Happy birthday on Friday. I'm going to try to remember all these, you guys. Auntie M, get the spreadsheet. Okay, so what I was going to show you guys. Okay, y'all know about the Temptations Prey, right? Right? We're there. I found Temptations wet food. Now they've been getting Fancy Feast, and that's like all they'll eat is Fancy Feast. And it's one of the most expensive. Well, not one of the most expensive. Okay, I'm exaggerating, but it is expensive. But this Temptations actually worked out to be one of the cheapest ones. And there's tasty chicken entree and seafood medley flavor. I am going to give this a shot. With as much as they love the Temptations Perez, I'm really hoping they like this. I also switched them for obvious reasons to Purina weight control. All right, buddy. Are we gonna do whoopsies? Ava, don't you dare. I stopped getting things with these little aluminum foil like lids because Ava learned that she could bite through the foil and eat the contents. So, all right, dude. Are we doing seafood or chicken? Always seafood. Okay. Let me see how this goes. No, this is not for you, Ava. You can have the lid. Not you. Here. You go over here. Here's your lid. I'm not holding it for you. Here, Billy. I hope you like it, buddy. And the other ones will be here in short order. It smells okay. Like, if I was a cat, I'd eat it. Hello, she's a maker. She's a maker. Oh, no. I pushed my keyboard all the way back. She's a maker. You missed my Halloween costume. Who am I? I was going to put the patch on it, but. Oh. See, this disturbed human, I covered him before. You will probably recognize him. But if you don't, I already have the link in the description to the original hearing of his. This is his sentencing. I actually came across it by accident, and I didn't recognize the name. But then when I heard the details of the case, I'm like, I think I know that guy. And I went back, and it was him. So I can't wait until you guys see this. Let's actually do that now. It's been a long intro, but I have missed you guys. Oh my goodness. So much has been going on with taking care of my father and everything, but you know what? The memories I have of my father when I was a kid, I don't remember like playing Barbie with him or, board games or anything like that because he wasn't there to do that. What I remember of my father was he was always working. I remember my dad coming home because he'd always have to deal with my brothers when he came home. But that's my main memory of my father was him coming home from work because he worked 3 jobs a lot, often. My father took very good care of our family. We didn't have a lot, but we were taught to appreciate everything that we had, and we had a lot of love. And so now that my dad is older and having health troubles, I want to take as good a care of him as he took care of us. So I'm sorry that occasionally I'll have to take some time off, but that's what I'm going to have to do. All right, guys. Let's watch a very disturbed, misogynistic individual and enjoy it.
All right, and this is People v. Justin Roth, file 23-6664FH. Counsel, you want to state your appearances, please?
Melissa Goodrich, Wayne County Prosecutor.
And good afternoon, Your Honor. James Gilbert here on behalf of Mr. Roth.
All right, and have you had a chance to, this is sentencing on the aggravated indecent exposure, 2-year misdemeanor with the advisory guidelines currently scored at 0 to 6 months. Any additions or corrections or scoring challenges from the defense?
Your Honor, I did go through the report and I have no additions or corrections to the report, and I believe the scoring is done appropriately.
Okay, Ms. Goodrich, any additions, corrections, or scoring challenges from the people?
No, Your Honor.
All right, anything you'd like to say on Mr. Roth's behalf?
Your Honor, I think the court is probably slightly aware from a lot of Mr. Roth's motions or the things that he does, that I do believe there is a mental health issue here that causes him to do some of these activities, and it's something that I don't think he really can control. I've had a lot of exposure with Mr. Roth, not in an type of aggravated way, but through the process of this case. And a lot of times you see this with Mr. Roth is that he has trouble controlling his emotions or controlling his activity. I would ask the court to consider that. I know one thing in talking with him and reading through the report, he was concerned that the report basically reflected that he was not remorseful for what happened. In his conversations with me, he says he is remorseful and wanted the court to know that. And I would ask the court to possibly consider he's factored out at 0 to 6. He's done very well on bond. We haven't had any issues with him. Any types of violations, I would consider the court to possibly having no jail sentence in this case. Thank you.
All right, thank you. Mr. Roth, you don't have to say anything today, but it is allowed. Is there anything you want to tell me or no?
Yeah, this past year has been tough in legal battles I've had in Sheboygan. I put the state of Michigan as a New Mexican through a lot, and wanted to apologize to the victim if she or her family is listening. And you know, I'm struggling a lot to work on relationships in my life, and I wrote a statement, but it just taking accountability for my actions and what a lack of maturity that I've shown, and how the medicine that I have been on since November of last year has brought my energy levels up, and there's less boredom and a little bit more determination to have a career and pursue something a little higher. So hope you take that into consideration, and that's it.
Okay, thank you, sir. Ms. Goodrich, recommendations from the people?
Yes, Your Honor. The defendant is 33 years old with no prior felonies and 4 prior misdemeanors. He's listed as currently unemployed. I was disappointed to read his reaction and subsequent messaging with the MDOC agent, and just the lack of remorse or accountability for his actions, and would ask the court to follow the recommendations.
Thank you. Well, Mr. Roth, you know, you're standing before the court for some disturbing conduct, that there is an agreement that this would be a non-registerable offense, and I agree with that. And it doesn't fit under the requirements for Michigan's SORA or catch-all provisions. So you don't have to register. But you've got a prior indecent exposure case. And in this case, you're driving down the highway, exposing yourself and masturbating and positioning your car to force other people to look at it. And then even during the pre-sentence interview, you say, well, 90% of women would like that. You are so gravely wrong about that. I mean, that is just a shocking lack of understanding to me, which is consistent, Mr. Roth. You consistently display a complete lack of understanding about how the world views your behavior. How you view your behavior, I promise you, what you think of your behavior is not what other people think of your behavior. Your behavior in our county the last couple of years has been deplorable. You've gotten to know now the circuit judge. That's not a good thing. And I've gotten to know you. That's not a great thing for you, because the ways that I've gotten to know you is your behavior, which is shocking at times, and how you interact with other persons is shocking at times. How you deemed it appropriate for you to interact with an agent of the Department of Corrections and the way that you treated them, the way that you have treated my staff on occasion, the way that you have treated attorneys trying to help you. Your comment that you're very disappointed that except for your lawyer and the judge, everybody's been a woman dealing with your case shows a level of misogyny that is troubling as well. You are a deeply disturbed individual, Mr. Roth, and I don't know that you have any understanding of that. In any event, there are some financial assessments here. $130 as a crime victim's assessment, $350 in court costs. You have to comply with DNA testing and pay a $60 fee, and there's $68 in state costs. I don't think probation would work at all. Nobody in the system seems to be able to communicate with you in a way that makes any sense. So I have no confidence that you would do anything on probation to comply. You have, although the guidelines are 0 to 6 months, a pattern of sexual deviancy and statements showing a total lack of understanding and remorse. There is a cap on 90 days jail. I'm going to impose all 90 of those days with credit for 2 days previously served. That's the sentence of the court, Mr. Roth. You can appeal it if you wish by filing an application. If you want me to give you a lawyer, I would do so, but you'd have to ask me within 6 months. We're going to hand you some of that appeal paperwork. You can fill it out if you want to take an appeal, and we're going to ask you to initial 1 copy for us. And you have to serve the sentence forthwith and go with the deputies at this time.
Oh yeah, you guys get to see him sign, and he doesn't get cuffed here, but you absolutely get to see the walk of shame. How someone can be so grossly wrong and just gross is beyond me.
We also have people be Kason Kreft,
Yes.
24-6899FH. For docket call, but also we have a motion to quash. So we'll go ahead and I've reviewed the motion to quash and the answer to the motion and the transcript of the preliminary examination. Go ahead and argue your motion.
Thank you, Your Honor. Your Honor, as to the motion to quash bind over preliminary examination was held on the felony charge in this case on August 23rd. As a result of that preliminary examination, the matter was bound over. The district court asserted a finding of probable cause on the allegation of fleeing and eluding in the 3rd degree, which encompasses 6 elements, which the defense is taking issue with elements categorically 4 and 5. Largely, Your Honor, the defense is asserting that there was insufficient evidence on the record below as to whether Mr. Kreft actions in the testimony that came in at preliminary examination satisfied these elements of general intent, specifically as to whether Mr. Kreft knew of the order to stop, and that he refused to obey the order by trying to flee or avoid being caught. The defense provided a summary of testimony in its motion, Your Honor, that came through an attachment on the transcript as well. Largely, Your Honor, our position is that the actual evidence that came in at the preliminary examination is largely based on the testimony of Deputy Supernal and his observations of Mr. Kreff's actions that day. The defense asserts that case law here for fleeing and eluding in the third degree highlights the behaviors and the actions of the driver, and those actions and behaviors that may constitute an inference that the driver knew of a lawful order to stop and then subsequently refused. For instance, in People versus Grayer, acceleration after an officer activates flashing lights can constitute that inference, Judge. And here, the testimony that came in at preliminary examination was that Mr. Kreff was essentially identified as speeding before the officer even decided to pursue him.
Right, but then it sounded like there was at least an inference that that speed increased, because then by the time the officer pulled off the pursuit, he was at 118 miles an hour. So the speed had increased during the pursuit.
That's correct, Judge, and the transcript would indicate that the speed, as testified by Deputy Supernault, had increased, and Deputy Supernault did not indicate via flashing lights or sound signaling for Mr. Kreff to stop until several miles down the road when that speed was identified and outside of his cone of speed detection. His testimony was based on an observation or an increase of RPMs, I believe is what he said. So our position is that the knowledge that's imputed to Mr. Kreff certainly.
Well, hold on a second. That doesn't make a lot of sense to me, because if the officer pulls off the pursuit once he's at 118 miles an hour, I should infer, shouldn't I, that he turned on his lights and sirens before he reached 118 miles an hour, because you wouldn't turn on the lights and stop the pursuit at the same moment in time. So he initiates the pursuit. The speed is increasing to the point that the officer pulls off the pursuit in the interest of safety. Isn't that what I should infer from that testimony?
Somewhat, Your Honor, only in that this is two different sections of the road. So the testimony was that Deputy Supernault first observed Mr. Kreff back near Aloha Township. As Mr. Kreff was proceeding north on M33, that's the testimony that came in, that Deputy Supernault began to hear an increase in RPMs. He then began to track the vehicle for several miles without lights, without sirens, and even in the flow of traffic was passing vehicles with the bike. At the point where Mr. Kreff approached the intersection of Straits Highway and 33 is when the decision to continue following Mr. Kreff on southbound Straits Highway was when the speed acceleration was identified at the number the court has just stated, right, and the lights were activated.
Well, the lights were activated near Carter Road just before Pier 33.
Right, Your Honor, as they approach that intersection.
Okay. Okay, so then after the lights are activated, then Mr. Kreff pulls up to an intersection, which presumably he couldn't navigate at 118 miles an hour.
Correct.
Turns south onto South Straits Highway and then accelerates.
Correct.
Wouldn't that be enough, even aside from his later statements, for at least a probable cause standard?
Well, Your Honor, the defense would argue no. There's several cases, although unpublished, that indicate speed is not a determining factor for inferring intent as to the fleeing and eluding, specifically in People versus Grayer, 252 Mishap 349 in 2002. That case indicates no vehicle speed threshold alone corroborates an acknowledgement of an order or refusal of an order to stop. So the defense's position is that Mr. Kreff had to assert some other acknowledgement by his actions or behaviors, like accelerating after acknowledging flashing lights, in order for that to be probable cause for that element.
Okay. And what about the statement? So once Mr. Kreff is stopped by operation of physics, then the officer approaches him, says, "Why didn't you stop?" And he says, "I was scared."
By way of physics. is a very wonderful way of the judge saying, you know, by him crashing at that speed. He's lucky he's alive.
Isn't that enough at least to get it to a jury?
Well, Your Honor, the assertion here was that Mr. Kraft had just been in a vehicle collision. He was tossed into the middle of Wing Road when Deputy Supernal noticed the cloud of dust and identified and found Mr. Kraft. As the allegation is, he approached Mr. Kraft in that position when Mr. Kraft verbalized being scared. And our position is not that he was identifying that he was scared of the officer being fleeing or looting, but rather his statement here cannot be interpreted as what it is merely for the fact that he had just been in a traffic accident. I mean, his ability to be cognizant of what the officer was trying to relay is hard to interpret based on that limited information we receive at prelim.
Okay, thank you. Ms. Goodrich, prosecutor's position.
Thank you, Your Honor. I believe that People versus Grayer is being misstated or misinterpreted. It just says that the speeding doesn't have to reach a certain level. It's not like, hey, once you reach 100 miles per hour, that's fleeing and looting. It's just saying there's no magic number or there's no magic time of the speeding. I believe is how I interpret Grayer to say it, and we agree. It's looking at the totality of the circumstances here and the decisions, the actions, the speeds, and the route which Mr. Kraft chose to take. And that, coupled with his statements at the end, gave enough for the court to bind over, and also for the jury to interpret what his statements mean to them when they look at the decisions he made, the speeds he went, and the decisions of the officer that once he reached with his sirens in his patrol car, marked patrol car, once Mr. Kraft reached 118, that it was no longer safe to even follow him any longer.
Thank you. Rebuttal argument, Ms. Libby?
Thank you, Judge. And I think that the speed determination in Grayer is important because the allegation here is that because of Mr. Kraft's speed at the time of his the testimony came in from Deputy Supernal was identified, in and out of the cone of detection because of their distance apart. Also, at times when the vehicles are close together, the sirens are not activated. What we're trying to interpret at prelim was whether this defendant knew he had a lawful order to stop and then refused it. And so the defense's position here as to his actions are not discernible between a 19-year-old driving a motorbike at high speeds because he can, or whether a 19-year-old is driving a motorbike at high speeds because he's avoiding the police. And that was not distinguished at preliminary examination.
All right, thank you. Well, the standard, of course, at a preliminary examination is whether there's probable cause that a crime was committed and that the defendant committed it. And on a motion to quash, this court reviews that decision for an abuse of discretion. I can't say here that it's an abuse of discretion to bind over on a probable cause standard where the testimony was that the officer activated his lights and sirens. And then after that, the defendant increased his rate of speed. The speed got to such an extent that the officer had to pull off the pursuit in the interest of safety. And then Mr. Kraft continued at a high rate of speed, putting down his bike in some fashion. And I'm glad he survived that at those speeds. That sometimes doesn't end well. So I'm glad he's here today. And then especially the officer walks up to him and says, "Why didn't you stop?" And he says, "I was scared." I think it would be an extraordinary thing for me to take this out of the hands of a jury based on that testimony. So I would deny the motion to quash. We probably should set this for further docket call then, the motion having been resolved. Is that correct, Ms. Libby?
Yes, Your Honor.
Okay, we'll set it for further docket call November 26th at 10:50 a.m. Okay, we'll see you then, Mr. Kraft.
Thank you, Your Honor.
Thank you.
All right, and our last case on the morning docket is Norvell. It's an appeal file 24-9081AR. Counsel, you want to state your appearance beginning?
Mr. Goodrich, Wayne County Prosecutor.
Dr. Amber Libby, Your Honor, on behalf of Kyle Norvell, who's present in the courtroom to my right.
All right, and this was your appeal under 6.106H1 of a bond decision of the district court on a misdemeanor case. Anything you want to say in support of your appeal?
Yes, Judge, thank you. This court issued an order directing the parties on appeal dated September 21st, 2024. And in it directed the parties to address several questions at oral argument. One, whether the district court abused its discretion by failing to articulate sufficient reasons on the record why release on a PR bond with conditions would not have sufficiently secured Mr. Norvell's appearance or protect the public. As the court's aware through this party's appeal, Your Honor, the original arraignment hearing on the driving while license suspended misdemeanor allegation, the reasons on the record that we can point to would be the court enumerating Mr. Norvell's traffic violation history and the current allegation of driving while license suspended. At the time of the original arraignment, the court did not note a specific concern as to public safety or a threat to the public based on the nature of that charge. Additionally, there was no statement as to Mr. Norvell being a flight risk to the court's concern. Subsequent to that hearing, Your Honor, the court held a motion to amend the bond hearing the very next day. At that time, the court claimed that the offense of driving while license suspended carries a potential to threaten public safety, but did not specifically assert reasons why Mr. Norvell was a reason to public safety. Your Honor, so the defense position on appeal with regards to the authority set out in 6106H is largely to enlighten this court as to our position that the district court did abuse its discretion when it set a cash-only bond in that matter. Additionally, Your Honor, this court directed the parties on appeal to answer the question of whether the district court erred by eliminating the possibility of Mr. Norvell being able to post bond by cash or surety. Your Honor, it's the defense's position under 6106E that the court rules read that the discretion belongs to the defendant, whether they're posting cash or surety as directed by the court. There's a difference in the court's authority there, but it is rather whether the court can order full money bail amounts or partial bail amounts, such as 10%, not whether Mr. Norvell can choose between cash or surety. He holds that discretion, and that's the defense's position. The court also asserted that there was potential, oh, sorry, Your Honor, strike that. The defense position as to this appeal, Your Honor, is really to recover Mr. Norvell's discretion in his ability to post his bond. The issue here was not really the amount. We understand the court set the amount in reference to what it perceived as a potential public threat the next day on the motion to amend the bond, but really was removing Mr. Norvell's discretion as a defendant in how he posted that bond, which triggered this appeal. I'm asking the court to remand and reset Mr. Norvell's bond and allow him to post that bond through his discretion by surety or cash. Thank you.
Okay, thank you. Ms. Goodrich, people's response?
Your Honor, I was coming for Mr. Juliet today. He thought this may be adjourned just because Mr. Norvell had recently turned himself in. He currently is in, his bond is revoked at this time, so it's kind of a moot issue due to some contempt charges in the lower court.
Okay, so I guess I do have a question about that. I know when we tried to convene the oral argument last week and Mr. Norvell was on warrant status for not complying with the district court's order. And so then there was an arraignment, I suppose, after he did turn himself in on the contempt. So does that render this issue moot? And if so, should it nonetheless be addressed, or what's your position on that?
Well, Judge, Mr. Norvell actually had issues that were running concurrent with each other. There was a previous file that he had been show caused for as to a failure to pay fines and costs. Mr. Norvell was notified about that 2021 file, made a payment subsequent to that, turned himself in on the warrant in the district court for this matter, Your Honor, and was arraigned as to those failure to pay fines and costs. So there was a couple matters occurring parallel. I would argue that the appeal was triggered from a bond order that still exists. Certainly the bond order could be reinstated today if the court were to do so. And he would have a bond order existing in those contempt files as well. So I would argue the issue is not moot, Your Honor.
Okay, thank you. And the appeal briefing that you had filed before had outlined the issues very clearly for me. And then in response to my previous order, the transcripts were prepared and submitted. And when I reviewed the transcripts, it really sort of highlighted for me the facts. And so I was able to sketch out a written ruling, which I'll read at this time and sign and enter into the record. On September 17th, 2024, defendant was arraigned by the district court magistrate on a charge of driving on a suspended or revoked license, DWLS second offense, a 1-year misdemeanor. The magistrate noted defendant's terrible driving history, including 6 DWLS convictions, multiple convictions of driving without security, and 2 operating while intoxicated convictions, all within the last 6 years. The magistrate also noted that a few days before the instant charge, defendant had been given a verbal warning about driving on a suspended license. The magistrate was concerned that defendant continued to drive illegally with disregard for the law and therefore did not set a personal recognizance bond. Instead, the magistrate set a cash-only bond in the amount of $5,000. Defendant filed a motion to amend the bond, which was heard by the district court judge. In denying the motion, the judge indicated that defendant's repeated driving behavior did raise a legitimate concern about public safety, justifying the setting of money bail. The judge also noted a prior history of defendant failing to appear. Defendant filed an appeal to this court under MCR 6.106H1. Defendant first argues that it was an abuse of discretion not to grant a personal recognizance bond. However, there were legitimate concerns based on defendant's history for both public safety and non-appearance. Therefore, this court cannot find that denial of release on personal recognizance was an abuse of discretion, of the district court's discretion. Defendant also argues that the setting of a cash-only bond without allowing to post surety for the bail amount was an abuse of discretion because it constituted a legal error. Defendant is correct in this regard. MCR 6.106E, 1A, and B expressly provide that when money bail is set by the court may require the defendant to post at the defendant's option, either a cash deposit or a surety bond. The court may specify whether the cash deposit is for the full amount or 10%, and the court may specify whether the surety bond must be for the full amount or 1/4 of that amount. But the plain language of the court rule does not allow the court to require a cash deposit only, removing the ability of the defendant to exercise their option to post a surety bond rather than a cash deposit. Of course, complicating this issue is that the defendant has subsequently been arrested on a warrant for contempt in the same case, which may render the initial bail decision moot. I'm not entirely clear on that point, but certainly given the short timeframes in misdemeanor cases, this legal issue should be addressed going forward. Therefore, it is ordered that the bail decision of the magistrate on September 17th and reaffirmed by the judge on September 18th setting a cash-only bail is hereby reversed, and the matter is remanded to the district court to set bond in accordance with MCR 6.106. And I'm signing and dating an order to that effect on today's date, Slibby, so that it can proceed efficiently back to the district court.
Thank you.
Okay, thank you.
Thank you.
That was actually kind of interesting. So it was not considered an abuse of discretion and power that he was not issued a PR bond, but he did manage to find a legal loophole that allowed him to get the bond decision reversed and sent back to the district court to be reissued. So that is, wow. I can't say that I've seen that a whole lot, but hey, there's always one, right? Chitty, thank you so much. I love it here too. Well, y'all act like an old cranky married couple. I miss him when he's not here. Oh, I think that should still be an occasional thing. Unfortunately, it was just, only a couple of people. If we had more people wanting to come for movie night, we'd do more new movie nights. There's a few more of the considerations on abuse of power decisions. So there were a few of them on the docket. I actually find them quite fascinating. And then there is also a kind of like a little bench trial with an officer witness, and this was like three separate Gauthier dockets that I edited and mushed together, and I only kept the interesting stuff and discarded all of the stuff that was just, blase.
All right, and we did have up People v. McConnell 24-6910, and we did hear from Mr. Funk's office. There was a hiccup on his end with the communication on that, and they're asking us to reschedule the arraignment then. Any objection to that, Ms. Goodrich?
No objection.
Okay, we'll put it over 1 week to next week, October 29 at 1 p.m.
Oops, I guess I missed that one. After I just got done saying I didn't keep any of the boring stuff. And then literally right there's just can we set over an arraignment? Yep, okay. Oy. I amaze myself sometimes.
That brings us to, that's Mr. Zilla, right? All right, so let's call People v. Louis Zilla, file 24-6777FH. And we're here for an arraignment on a probation violation warrant. Counsel, you want to state your appearances, please?
Melissa Goodrich, Blaine County Prosecutor.
Dr. Amber Libby, Your Honor, on behalf of Louis Andrew Zilla Jr., who's present in the courtroom to my right.
All right, and Mr. Zilla, it's alleged that you are in violation of your probation in the following respects. Technical violation in that on or about August 16th, you were in possession of the controlled substance buprenorphine. And it's alleged that you also committed some non-technical violations from that conduct, meaning that on the same date you engaged in behavior constituting a violation of criminal law, in that as an inmate in the Sheboygan County Jail, you were in possession of contraband, specifically the controlled substance buprenorphine. And also in count 3, that on or about the same date, you engaged in behavior constituting a violation of criminal law by being in possession of the controlled substance buprenorphine. You have the right to have a hearing on those allegations where they would need to be proven by a preponderance of the evidence, and the right to the assistance of a lawyer. And if you qualified and requested an attorney at public expense, you have the right to cross-examine the witnesses presented against you and to present witnesses in your own defense. You are on probation to me for a charge of aggravated domestic violence, second offense, which carries with it a maximum penalty of 5 years in prison. If you were to be found guilty of the non-technical violations or plead guilty to them, I could revoke that probation and sentence you on the underlying charge. Mr. Zilla, do you understand the rights you have and the penalties that you face? And Ms. Libby, do you know how it wishes to proceed?
I do, Your Honor. Mr. Zilla and I discussed the nature of the allegations of probation violation. The allegations here, I believe, are contained in the body of a new file that Mr. Zilla has received a bond on in the district court. I believe that bond was set at $50,000 cash or surety. In any event, Your Honor, he's pled not guilty in that file. We would enter a plea of not guilty here and request a contested hearing.
Okay, we'll enter in plea of not guilty. Is he still serving my initial sentence in the jail?
I do not believe so, Your Honor. I believe he's held on a bond he cannot post at this time.
Okay, so Mr. Zilla, did you already finish serving the initial sentence in this matter?
Yes, Your Honor.
Okay, so why are you're in custody right now on the arrest for the new charge?
Yes, Your Honor. When I was arraigned, it was agreed upon 50,000 and with the condition of rehab, because I was going to rehab before any of this happened, after I concluded that sentence. But that concluded on October 4th.
Okay, and so he's in jail on the complaint on these for the same conduct, and then on this warrant. Am I understanding that right?
That's correct, Judge. My understanding is the nature of this warrant is a no bond. Defense would motion for this court to allow for some bond so that Mr. Zilla's underlying attorney can motion to amend his bond and release to inpatient treatment.
All right, Ms. Goodrich, people's position.
Your Honor, he's scheduled for a preliminary examination on the pending charges on Friday, this coming Friday, October 25th. He is represented by Mr. Gilbert in that matter. I was presented a stipulation for him to go to rehab, but he still was under sentence at that time, so I declined to sign it, but I have no objection if he were to go to inpatient treatment and then return to the jail after completion until he posted bond.
Okay, well, and I guess once that gets sorted out, people can present that by stipulation or motion. I have to tell you, I'm not sure whether I would sign that, Mr. Zilla. I'm kind of looking at my notes to refresh my recollection, and I think you were kind of on the bubble with me initially, whether to give you jail or prison, and you sure haven't helped yourself. So, you know, this might be a case where I'm looking to revoke your probation and send you to prison. I'm not entirely sure. So at this point, I'm going to order you to be held without bond in this probation violation. You're on probation for a serious felony. And while you're doing that, even before you're out of jail, you commit another felony. It's alleged. So you're going to remain in custody until we sort this out. And because you're in custody, I'm required by the court rule to set the hearing within 14 days. We'll schedule it for November 5th at 2:30 in the afternoon. And we'll refer it to the Office of Assigned Counsel for it to be referred again to Mr. Gilbert. And I guess I'll set aside a half an hour and allow that to be an evidentiary hearing then, because he is in custody. If the parties, you know, don't want to do that, if you can let the prosecutor know, you know, as soon as possible so that they don't have to subpoena the folks.
Thank you.
Okay, we'll see you then, sir. And we'll call next, people be Aaron Field. A couple matters. A status conference on a pending probation violation in file 23-6630 and an arraignment in file 24-6914. Counsel, you want to state your appearances on the record, please?
Mr. Goodrich, Plain County Prosecutor.
And good morning, good afternoon, Your Honor. James Gilbert here on behalf of Mr. Field.
All right, and I did speak with counsel at the bench briefly just to sort of update them on what I understand the timeline of Mr. Field's prior and current cases to be, and expressed a desire that maybe with the assistance of some family, we can see if we can address any treatment needs that could address the underlying behaviors. But in terms of the arraignment, Mr. Gilbert, have you had a chance to review the charging document with Mr. Field?
Mr. Field is aware of the charging document, Your Honor.
All right, do you or he wish to have its allegations read?
We'll waive the reading.
And how's he wish to plead the charges?
He'll stand mute.
All right, so I'll enter a plea of not guilty on your behalf, Mr. Field, to the 2 charges of aggravated stalking, habitual fourth. Is a forensic center referral requested?
It is not.
Would be the estimated length of trial?
2 days max.
Set this out for docket call, say, November 26th at 2:10 in the afternoon. Does that sound fine? And we'll continue the status conference on the pending violation in the probation matter to the same date and time. Any objection to that plan, Ms. Goodrich?
No objection.
So Mr. Field will next see you November 24th at 2:10 in the afternoon. And given sort of the track record of these cases, what I told your lawyer and the prosecutor was that you seem to be on a fast track to prison now in this case. But if there's any way to get us off that path, it's going to involve some kind of mental health treatment. I don't know why you keep engaging in the things that you're engaging in. And if there's any kind of way we can address that, I'm open-minded to listening to that, but otherwise we're on a bad path now, Mr. Field. But I'll see you next on November 26th at 2:10 in the afternoon.
My client didn't want me to ask, Your Honor, if there was any possibility of establishing a bond in this file.
It is really not a chance of that, Mr. Field. You're on probation to me for aggravated stalking, and now you're charged with aggravated stalking in 2 counts against additional victims. There's no way I'm going to let you out of jail until we resolve these matters and see what our plan is. And our plan is either going to involve, if you're innocent of those charges, it's going to be a trial and an acquittal. If you're guilty of those charges, it's going to be either treatment or prison. So we're going to have to sort those things out, but I'm not going to release you on a bond on the probation matter. All right. Right. Well, that brings us then to our 3 o'clock docket, and people be Wyndham Rieger.
Good afternoon, Your Honor. Luke on behalf of Mr. Rieger.
Mr. Juliet, are you for the people on this one?
I am.
All right, and this is a docket call and also a motion to suppress. I reviewed the motion and the response to it. Any opening argument before we receive some testimony on your motion, Mr. Kukeski?
No, Your Honor.
Mr. Juliet?
No, Your Honor. Thank you.
All right, and so Mr. Juliet, are you presenting the arresting officer for testimony?
I am. I would call Deputy Plotski.
Okay, Deputy Kolatsky, you want to come on up to the witness stand, please? Please raise your right hand for me. Do you solemnly swear that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, and Mr. Juliet, the motion being filed, it's the people's burden to go forward with it. I'll let you conduct the examination first.
Thank you. Deputy, can you state your full name and spell your last name for the record?
Darren Kolotsky, Kolatski.
Where do you work?
Sheboygan County Sheriff's Department.
How long have you worked there?
Just over 2.5 years.
What is your job title?
Road patrol deputy.
Were you working on April 10th of 2024?
I was.
Did you have some contact with the defendant in this case on that day?
I did.
Do you remember what time during the day?
It was later at night.
Was it light out or dark out?
It was dark out.
What caused you to have contact with the defendant that day?
I was doing stationary patrol and had a vehicle approaching me that I heard hit the rumble strips straightaway. So I began following the vehicle to get some tracking on the driving and observed the vehicle left its center twice while attempting to navigate the curves on North Straits Highway.
So where was it, closer to Indian River or closer to Sheboygan on North Straits Highway?
It was just north of Hoppinaby near between Mullet Road and Woodman Z through the curves.
And at what point did you first make contact with this? When did you see this vehicle?
While I was conducting stationary patrol from Old 27 Road, watching North Straits Highway, I was watching southbound and northbound traffic, and I seen the vehicle traveling southbound on North Straits towards me.
Okay, so if you're, what side of the road were you on, do you recall?
Would have been the south side of North Straits,
Closer to Mount Lake or on the opposite side of the road?
closer to Malt Lake.
So this vehicle, it was traveling south towards Indian River.
Correct.
And when you first observed it, was it, I guess, would it have been on your right, looking over the passenger's side of the vehicle?
It would have been straight out in front of me. Where I was positioned, I was on a side road that looks directly down a straightaway onto North Straits Highway.
Did you make any other observations when you initially saw the vehicle?
I activated the radar in my patrol car and had a reading of about 49 miles an hour, vehicle traveling towards me.
What's the speed limit in that area?
55.
So at some point, did you pull out behind the vehicle?
I did. I activated my radar, seen the vehicle was doing 49. I turned my radar back off. My window was down and it was the only vehicle coming at me, so I could hear it hitting the rumble strips on North Straits. I couldn't see from where I was if it was the center line or the fog line rumble strips, but it was enough for me to leave my stationary position and go attempt to get tracking on the vehicle.
Yeah, if you're hitting the rumble strips on a straight highway, it happens. But if you're also doing it while you're going 5 miles under the speed limit, it's a pretty good indication that there may be something going on that the officer wants to check on.
Were there any other vehicles in this vicinity?
No.
So what happened after you pulled out behind the vehicle?
As I began catching the vehicle, somewhere it was just south of Mulletburg Road where I was close enough to see the vehicle in its lane. I observed the vehicle wandering back and forth in its lane and beginning to navigate the first curve, where I observed the vehicle across a double yellow line.
How long did you follow the vehicle for?
From the time I got behind the vehicle to the traffic stop, maybe 2 miles.
So you said you observed it cross the double yellow line. Are you referring to the center of the road?
Correct.
Were there rumble strips in the center of the road there?
Correct.
Okay. Did you hear him hit any of the rumble strips then?
I had my window up. I couldn't hear the rumble strips while I was catching up to him, but I observed the vehicle cross the line.
And this was while he was trying to navigate a turn?
Correct.
Okay. Was it the only one, there was only one time that you observed him cross the center line?
No, there was 2.
Keep it between the ditches.
And eventually you made a traffic stop?
Correct.
No other questions?
Proceed.
Thank you, Your Honor. Deputy Klasky, do you remember what the weather was like that evening?
I believe it was clear and dry out.
Okay. And the road that you were sitting stationary on, was there also another road going off of Straits Highway? Near that road? Like an intersection?
Yes.
Okay. And do you know if there are any vehicles on that stretch of road?
I could not see that secondary road completely.
Okay. And so you do not know if there's vehicles traveling on that road could have caused the rumble strip noise that you heard?
I do not believe there is rumble strips on Long Point Drive.
Okay. So you hear the rumble strips, you don't observe any driving by my client at that time, correct?
Correct.
And then you clock them going slower than the speed, maybe 5 to 7 miles an hour slow.
Correct.
And then you formulate the basis, or you decide to then get behind them to conduct a traffic stop.
I decided to get behind them to get tracking on the vehicle.
Okay. Tracking as in,
I was attempting to see if it was the vehicle that was hitting the rumble strips due to it was the only vehicle in front of me and I heard rumble strips, so I pulled out and got behind it to verify if that was the vehicle that was hitting the rumble strips and get tracking on their driving to see if they were the ones hitting the rumble strips.
okay. And so while you're catching up this vehicle, you indicated I believe you saw him cross the double yellow lines.
Correct.
At what distance was that?
Maybe 50 to 60 yards as I was just getting close enough to see the vehicle within its lane comfortably enough to start getting tracking on the vehicle.
Okay. So you pulled out, you're catching up, you say you observed this, but you don't hear any rumble strips at that time either, correct?
I could not hear the rumble strips from inside the patrol car while I was driving with the windows up.
Okay, and this is while that vehicle is navigating one of those curves on the roadway as you're heading towards Top of Me.
Correct.
Okay, and you didn't effectuate a traffic stop?
Not right away.
Okay, so you continue to follow the vehicle?
Correct.
And then you, again, observe it, you say you cross the center line again.
The second time, correct.
Okay, and where was that at?
Would have been the curve just north of Woodmansey Road.
Okay. And how close, what distance were you from the vehicle at that time?
Maybe 2 car lengths behind the vehicle. I caught up to the vehicle by that time. After the initial left of center, as I was catching up, I caught up to the vehicle and through the next curve is when I witnessed the vehicle across the center line a second.
Okay. And where at this time, had you run the vehicle? Were you running the plate, identifying the vehicle?
After the second left of center, I believe I was attempting to run the plate once we were through the curves. I'm looking for a safe place to initiate the traffic stop.
Okay. Well, isn't it true that there are multiple safe places to stop that vehicle on that road?
I wasn't comfortable making a traffic stop yet where I was located.
So I just want to point out a very important piece of the officer's testimony that just happened there. He said that he ran the plates after the curves. Okay, so he had been behind this individual that was crossing the center line, weaving through the road and hitting the rumble strips. So he'd been behind him for a minute before he ran the plates, and that's going to be a very important thing.
So, and the traffic stop occurred just outside of the Top of the town, or the entrance in the Top of where it slows down, is that correct?
Correct.
Okay, and so from that distance to where you first observed it on Long Point Drive, you estimate that to be about 2 miles, not close to maybe 3 or 4?
It could be 3 or so, I guess.
Okay. And so when you're making these observations, you again don't decide to conduct a traffic stop. Why is that?
I was getting tracking on the vehicle and waiting to get to the curves to look for a safe place to conduct the traffic stop.
Okay. Was it true when you pulled out behind the vehicle, at that point you were going to conduct a traffic stop?
No, I hadn't had enough information to conduct a traffic stop yet.
Okay. And so your testimony was you didn't run his plate until after you saw the second time when he hit the center line?
I believe so, until I was through the curves.
So after you see him, observe him hit the center line the second time, why didn't you conduct a traffic stop at that time?
Again, I was waiting for a safe place to conduct the traffic stop, and I was still gaining tracking on the vehicle.
Okay, so would it be true between Top and B And going back to where you're coming from, those curves, there's a long stretch of road there. There's about a mile of road there that's almost straight towards top. So there was not a safe place to conduct a stop at that time.
There could have been, but I believe I was running late as well.
Okay. So you just testified you were still getting tracking on the vehicle at that time. So you weren't, at that point, you hadn't yet got behind the vehicle to track it? Would that be your
I
testimony?
was continuing to build tracking the whole time.
Okay. Yeah, I don't have anything further.
Just one. The first time you heard the rumble strips, there were no other vehicles in the area that you observed?
Correct.
Thank you. No other question.
I had a question for you, Deputy. When you saw the vehicle cross the center line twice, can you describe to what degree it crossed the center line, or how far across the center line did it go?
I don't have an exact measurement, but it was the driver's side tires completely over the yellow lines, far enough that they would have just been coming off of the rumble strips into the opposite lane of travel.
Okay, thank you. Any further questions as a result of the court's questions?
I didn't have any as a result of that question.
No.
Okay, thank you, Deputy. Step down. Any other proofs offered from the people?
No, thank you.
Any proofs offered from the defense?
No, Your Honor.
Argument on your motion, Mr. Chakowski?
Thank you, Your Honor. And Your Honor, it's our belief and our understanding that at the time the officer pulled in behind my client or heard the rumble strips and then pulls behind my client, clocking him just under the speed limit, 5 miles per hour under the speed limit. He pulls behind my client to effectuate a traffic stop. Based on his report, doesn't feel it's safe there to do that. Follows my client for about 4 miles, observes these 2 additional driving related offenses that he says he hits the center line or crosses the center line. Our contention is that he had plenty of room to make that stop, whether it was curves in the road or not. He continued to follow our client so he could run Mr. Rieger and then effectuate a traffic stop based on the information that he gleaned from that, I guess, running his plate. So we'd argue that the stop was not based on any probable cause. He actually lacked probable cause based on hearing rumble strips and then I guess slower than average speed on that road, Your Honor. So thank you.
Thank you, Mr. Juliet.
Thank you. It's pretty well settled that the decision to conduct a traffic stop on automobile must be based on the officer's probable cause. In this case, the court's heard testimony from Deputy Flotsky that he was sitting stationary on North Straits Highway near Long Point Drive when he initially heard the vehicle that the defendant was driving hit the rumble strips, whether it was on the side of the road or in the middle of the road. In any event, there were no other vehicles around him, so it had to offend him. After pulling out behind him, he was starting to gain traction on the vehicle. He eventually heard or saw the defendant cross completely, based on his testimony, into the other lane while trying to navigate a curve on 2 different occasions. And although this isn't dispositive, it's fairly uncommon on that road to see somebody going under the speed limit. Most of the time it's over the speed limit. So in this case, I think the relevant section of the motor vehicle code is 257642, subsection 1A. Looks at for roadways divided into 2 or more clearly marked lanes for traffic. The vehicle must be driven as nearly as practical entirely within a single lane and must not be moved from the lane until the operator has first discerned that the movement can be safely made. In this case, I think there's 3 certain traffic violations. One is hitting the rumbling strips. That's completely outside of the lane. And then two separate occasions where he crosses completely into the left lane, potentially creating a hazard for oncoming traffic. So based on those together, and what I think is important is when I say those together, perhaps one of these violations alone may not have been enough for a traffic stop, but all of them collectively together gave the deputy probable cause to make the stop.
Well, I guess they may want to recall the officer testify some more, because I guess I'm unclear whether this was a stop for a traffic violation or on suspicion of drunk driving. So Deputy Klatsky, I'd recall you to see. Remain on the road, sir. And so I have a question for you. When you made the traffic stop, why were you stopping people?
For the 2 left of center violations.
You were not stopping the vehicle on suspicion of impaired driving?
It was a possibility, but I didn't have that for sure at the time of the initial traffic stop.
Well, I guess maybe explain that further, because you don't have to be 100% sure to pull somebody over for impaired driving. You need reasonable suspicion of it. Can you explain to us what was going through your mind? What was the reason for the stop? In total?
Sure. When I was sitting stationary and the vehicle was originally coming at me at 49 miles an hour, the only vehicle on that straightaway, and it hit the rumble strips on the straightaway while going under the speed limit, which was what initially caught my attention. They were on a straight road going less than the speed limit and still couldn't drive straight. So that was what prompted me to leave my stationary position and go investigate further. As I was catching the vehicle, I witnessed it wandering in its lane, and then drive left of center twice while navigating the curves between Bulletford and Woodman Z. So there was a suspicion of possible OWI, and I had the 2 traffic violations to initiate the traffic stop to investigate further.
Thank you. Any question as a result of the court's further questioning, Mr. Professor?
So I guess my question would be, your initial indication is that you hear the rumble strips, so you believe there might be an intoxicated driver coming at you.
Possibly.
Okay. Well, is it not uncommon for somebody that maybe is going to make a turn into their driveway, gets over on the shoulder road, hits those rumble strips?
It's possible, but the vehicle continued past me, and they weren't slowing down to make a turn into a driveway.
And then those very curvy roads that you're navigating, it wouldn't be uncommon for a vehicle to take those curves slower than normal, right? I mean, those are pretty windy roads, curvy roads, correct?
Possibly, but the vehicle was well below the speed limit all the way down the long straightaway before one point. He was continually at 49 miles an hour on the radar as he was coming at me pretty steadily.
And those curves are such in the road that you didn't even feel safe. Your testimony says that you didn't even feel safe conducting a traffic stop on those curves, correct? Because they're so windy. It's such a big curve.
Just for my safety and the safety of the driver of the other vehicle, I wanted us to both be in a position that oncoming traffic could see us from a good enough distance that they would be able to slow down and navigate around us safely.
So you admit those are very severe curves and bends in the road with that you're navigating.
Correct, they're pretty good sized curves.
Nothing further.
Further examination, Mr. Juliet? All right. Okay, thank you, Deputy. You can step down. All right, Mr. Kotesky, additional argument?
I guess my argument remains the same, Your Honor. The officer pulls out to effectuate a traffic stop. And it's not normal somebody drives this slow. I believe that there's an intoxicated driver coming at me because I hear rumble strips. But he hasn't seen that driving. He doesn't know if that's the vehicle that hit the rumble strips. Admittedly, there is another road that the officer testifies may not have rumble strips. They're not certain on that. Again, I think there's a lack of probable cause to effectuate that stop, or to give you a client to then continue to follow him. I believe it's when he runs my client, learns that he has priors, that he decides to now effectuate that traffic stop. So we'd ask the court to dismiss this matter as a lack of probable cause based on the stop.
Thank you, Mr. Juliet. An additional argument after the further.
I guess my argument's largely the same with respect to the reason for the traffic stop. Based on the court's questioning, I think the officer has provided reasonable and articulable suspicion of operating while intoxicated. I'll leave it at that.
All right, because I mean, the reason I asked that was that your written response posited two separate grounds for the stop. One is the lane violations, and two is reasonable suspicion of impaired driving. Okay. All right, well, in this case, the Fourth Amendment and the Michigan Constitution protect people from unreasonable searches and seizures. And when it's a moving vehicle, the case law says that fewer foundational facts are necessary to support a finding of reasonableness, as long as there's a reasonable articulable suspicion of some criminal activity. And here, although there were the lane violations, I think given the nighttime, the crossing of the center line a couple times, hitting the rumble strips, the officer thought there was a possible suspicion of impaired driving. I think that is a reasonable suspicion. The people behind case cited by the prosecution says that erratic driving, such as swerving within a lane and driving on the lane markers, can give rise to reasonable suspicion of intoxication justifying an investigatory stop. That was based on the People v. Christie case, and that's 206 Mishap 304. And in that case, the Court of Appeals said, in that case, the defendant's vehicle was seen swerving in the lane and driving on the lane markers. Defendant had his turn signal flashing for 0.2 of a mile before turning at Second Side Street. This would appear to be classic indicia of an intoxicated driver, because fewer foundational facts are necessary to support a finding of reasonableness when moving vehicles are involved. We hold that the trial court erred in concluding that the investigatory stop of defendant's vehicle was unreasonable. The investigatory stop was a minimal intrusion of defendant's Fourth Amendment rights in light of defendant's potential danger to the public. So although there wasn't the additional fact of a turn signal remaining on, sort of the factual background we have to assess this under is, there's a very serious public safety risk for intoxicated and impaired drivers. And all the Fourth Amendment requires is that the officer have some reasonable basis to suspect that he may have an impaired driver. And here, a vehicle hitting the rumble strips, and then the officer watches and observes the vehicle cross the center line twice, to the extent that not just even bumping it, but the tires cross over into the other lane on 2 occasions. I think, as in the Christie case, that is classic indicia of impaired driving. And the officer not only has a reasonable basis to make a stop in that circumstance, but probably surely ought to make a traffic stop in that situation, rather than waiting for the third time that the defendant crosses the center line and keeping our fingers crossed that there's not a car in the opposing lane. So I think there was an abundance of reasonable suspicion for the stop. The motion to suppress is denied. All right, so because we had that pending motion, we probably need to set this for additional docket call, Mr. Kopesky.
I would ask for that, Your Honor.
Well, I've got November 12th, but I don't have you currently scheduled that day. I do have you scheduled on November 26th. You just want me to add it on at that time too?
That would be just fine, Your Honor. Thank you.
Okay, so any objection to that, Mr. Julian?
No, Your Honor.
So we'll continue this to November 26th at 1:20 in the afternoon. And we'll see you then, sir.
Thank you, Your Honor.
All right, so let's call the Szymanski matter then.
Good afternoon again, Your Honor. Kopesky on behalf of Szymanski.
All right, and this is Szymanski v. Secretary of State 24-9066L.
This is another one of the abuse of power and discretion hearings, and it's quite interesting.
And you represent the Secretary of the matter?
Yes.
Okay. All right, Mr. Kukeski, this is your appeal. I've reviewed your petition and brief and the transcript and record. Go ahead.
Thank you, Your Honor. And briefly, Mr. Szymanski had a hearing with the Secretary of State to get his full driving privileges reinstated. He's currently on restricted driving privileges. He was denied in that order. And the reasons for the denial that the Secretary of State found was they were not persuaded that he was at a minimal or low risk of relapse. We actually disagree with that finding from the Secretary of State, as Mr. Szymanski had testified that he's been sober for over, well over a year, somewhere in 18 months to 2 years. He had provided letters from support, which the hearing officer also indicated were problematic because they did not indicate a sobriety date for Mr. Szymanski. Well, as I identified in my motion and in my brief, and I quoted the letters that said, I have not known Timothy to drink in the last 2 years. I have not seen Timothy to have a drink in the last 2 years. And so he provided ample support that he has not had any drinking episodes. He was in the Veterans Court in Mount Morenzi. He successfully completed that. He passed a drug screen. There was also an issue with the assessment that they were not provided with the proper scoring basis or the apparatus that led to the conclusion that he was at a moderate, I guess, level of intoxication or moderate diagnosis as for alcohol use disorder, but he was in sustained full remission, Your Honor. That was provided, and I did point out to the court where that was provided in the transcript as well. So given the testimony, letters of support, negative drug screen, the completion through Veterans Court, and then his successful, I guess, operation of the vehicle under the restrictions that he had with the sober-leak machine or the blow-and-go machine for, gosh, almost a year by the time we got to that hearing, I think was ample support and ample evidence to show the Secretary of State that he is at a low to minimum risk. The assessing agent even said he poses low to minimum risk. He also indicated the basis for his findings on whether Mr. Szymanski had a moderate alcohol disorder and that he was in sustained full remission. And so that also went to the hearing officers taking issue that there was no basis for those conclusions by the assessing agent. And given all that, Your Honor, and not to go in all into the brief that I submitted, I know the court's reviewed that. We think that the hearing officer's decision to deny my client and continue him on the restricted license status was abuse of discretion. It was arbitrary and capricious, and we'd ask this court to overturn that and give him his full driving privileges because he did demonstrate that he has maintained his sobriety for well over 12 months, which is the standard here, that he does pose a low to minimum risk of operating intoxicated again, and that he's got the tools in place. I know that lastly, I get the hearing officer took issue with, geez, he doesn't do any AA, he doesn't do anything there. Well, my client has been counseling with the VA. He sees a psychologist at least once a month now. Back when he was Veterans Court, it was more like a weekly basis. He'd also meet with the Veterans Affairs, and he would do the Seeking Safety course, which is veterans that get together and talk about their disorders, like AA, but it's for veterans.
AA specifically does not work for everyone. It's not supposed to. There are other alternative programs, however, that people can invest themselves in, like the Veterans Program. Preferring to do the Veterans Program and see a psychiatrist or psychologist as your means of treatment, it instead of AA, it does not make that a bad choice. then the court should not be able to hold it against you if you're enrolled in some type of treatment, even if it's not AA.
And my client testified at the hearing that I'm more comfortable around guys that I fought with, or the guys that were in a similar disposition as me, veterans. I wasn't comfortable in the AA setting, and I do these things through the Seeking Safety, the other veterans programs that he was involved in. There was another one, I just can't put my name, I just can't name it, along with the Seeking Safety that he did. Not to mention the monthly meetings with the psychologist, Your Honor, that he has. And so he's established a very good, I guess, basis or support system. If he does have any problems, he knows where to turn, he knows what to do. And again, I think that goes to his level of whether this is going to happen. Again, recidivism is low to very minimum, Your Honor. So we'd ask the court to overturn that decision by the Secretary of State. Thank you.
Can I ask you, this is sort of a timing aspect, and just something I wonder about as I preside over a treatment court myself. And in the treatment court environment where Mr. Szymanski found himself in, one of the benefits that they receive is that restricted license through the treatment court program, sort of taking a shortcut, if you will, through the typical process of trying to persuade the Secretary of State to give it to you, which is, as you are well aware, not a very easy task. In general, I'm not super persuaded by the Secretary of State's frequent position that sobriety on probation somehow doesn't count. So I'm not super persuaded by their thinking on that. However, where somebody got a restricted license in a treatment court environment, and then they graduate, and their hearings less than 3 months after their graduation, is it reasonable for a hearing officer to say, you know, we'd like to see a little bit more track record now that you graduated before we take those restrictions off? What should I make of that?
Well, Your Honor, I think that would be something that the court should look at in the Secretary of State on a case-by-case basis, and the evidence that's presented to them at the time of the hearing. So there's no restriction to having that hearing as soon as they graduate because they've gotten the license early. So it doesn't contemplate, well, geez, if they really wanted to deter that or to really look into that issue, there might be an extension of that time if they are in a treatment court program, or they should.
So the legislature could say,
Yes.
if you get an interlock through a treatment court, you have to wait 6 months or a year or something after graduation before you petition.
Essentially, that's my argument, Your Honor, that that's not the case, that there is no legislature out there that says that. And when you're going through that treatment court, you know, Your Honor, if you sit on the treatment court, how rigorous those are. And the success versus failure rate in those programs is sometimes not the greatest. And Mr. Szymanski had proven himself through that program. He's still continuing with his VA treatment in his course of, I guess, recovery and sobriety. And given all that, coupled with his successful completion of the sobriety court, I think there was enough there for the court and the Secretary of State to make that determination, Your Honor. So thank you.
Mr. Juliet.
Thank you. Proceedings brought under MCL 257-3234 restrict this court's decision to overturn the secretary to a review of the record. In this case, Mr. Kukowski is arguing that the hearing officer's decision was arbitrary and capricious, which means the decision is unreasonable, appears to be random, or is based on an impulsive or unmotivated notion. Michigan Administrative Code R 2573131A states that a hearing officer shall not order that a license be issued to the petitioner unless the petitioner presents by clear and convincing evidence that the petitioner's alcohol or substance abuse problems, if any, are under control and likely to remain under control. I sort of want to offer my opinion on the court's question of the interlock program through the treatment court and the timing of which this petition has been filed. I guess I share the hearing officer's concern in that the defendant drank while he was in that treatment court on probation. So I don't think it's totally out of line. It's certainly not arbitrary and capricious. for a hearing officer to take testimony and find out that just months ago, before this hearing, the defendant was drinking while on probation in the Veterans Court. And that, together with the fact that he's not in any sort of NA or AA alone, I mean, I just don't believe that is arbitrary and capricious or any sort of abuse of discretion. I think any reasonable hearing officer would want to say, you know, you drank while you were on probation in this treatment court. We're barely past your graduation date. I want to see a little bit more progress to show that, you know, this is likely not going to happen again. So with that being said, I would ask the court to deny the petition for full privileges.
Your Honor, if I may,
Yes,
the consumption of alcohol while he was in sobriety court
that was 16 months before.
was, yes, we wouldn't even been awarded a hearing if it was under 12 months, which is the requirement under the statute.
Well, in this case, Mr. Szymanski had a revoked license due to repeat drinking and driving. He received a restricted license with an interlock program through a treatment court program. A couple months after he received that restricted license in January 2023, he did have a drinking episode, although it didn't involve the vehicle. The court did not pull his license at the time, continued him on the restricted license, and 13 months later, with no further relapse history, he graduated from the treatment court program on April 24th of 2024. Then he petitioned for the removal of the restrictions and full driving privileges, and had a hearing on July 16th, 2024. This court's review is as an appellate court, not, you know, would I have given him a license, but was to review the propriety of the hearing officer's decision. So some of the bases to reverse that are, is it a clear abuse of discretion, or was the hearing officer's decision not supported by competent material and substantial evidence on the whole record? Here, the hearing officer gave several reasons for not removing the restrictions and not restoring full driving privileges. First, that the substance abuse assessment did not include the screening tool. Well, that is demonstrably wrong. It's attached as part of the record. And there's the SASE scoring inventory, and it was referred to by the assessing officer, Mr. Green, who's, you know, pretty experienced in those matters. Second reason was that the letters of support weren't clear enough in terms of when he stopped drinking, and wasn't there an issue with like an old marijuana use or something? Am I remembering that right?
That is correct, Your Honor. You are remembering that correctly.
There we go. But you know, the letters need to clearly give information to show that they're reliably vouching for the fact that this petitioner is not presently consuming alcohol or abusing drugs, and they were reliable. I mean, but the expectation that the letters have to be from the old drinking buddies that can say, I saw him drink 7 beers on Monday, Wednesdays, and Thursdays for 17 years, and then on X and such date he stopped, and now he hangs out with me all the time and he doesn't drink. Well, that's totally contrary to what we want people to do, to change their people, places, and things. So we don't want them hanging out with the old drinking buddies. So I'm oftentimes perplexed by some of the hearing officer's objections to these letters. The letters just have to be from people who can document that he's sober. They did. And the marijuana usage was so long ago and so minimal to try to ding the letters because they weren't aware of when he last smoked weed, I think was an abuse of discretion as well. The hearing officer also said, well, he's not attending AA. Now, the petitioner says here, well, I'm attending treatment and counseling and seeking safety. Treatment is different than support. So I don't necessarily buy that argument completely. However, There's no statutory requirement that you engage in support group meetings to get your license back. It depends on what's recommended. And when I look upon the substance abuse evaluation, has excellent prognosis for the petitioner to remain sober and not reoffend. And in the recommendations, it has support from his family and friends, and it describes some of the counseling he's doing and some things like that, and his family and friends support. There's a box to check for community support groups such as AA or NA, and Mr. Green did not recommend that. So the hearing officer says, well, I'm not going to give you your full license because you're not going to AA, even though the substance abuse professional doesn't recommend that you do so. That doesn't seem to be a decision supported by competent material, substantial evidence in the whole record. The hearing officer further said, well, there was a relapse, but that relapse was 16 months prior to the hearing, well beyond the time limit required under the statute. And the hearing officer said, well, you just graduated from the treatment court. Now, I got to tell you, when I first reviewed this, I sort of agreed. And we have oftentimes told our treatment court graduates, you're going to want to show a track record of a year after graduation before you go to the Secretary of State. However, I guess I find persuasive Mr. Kukuski's argument today that the statute could say that, and it doesn't. It has a period of sobriety that I think Mr. Szymanski did present clear and convincing evidence that he had established. And it requires clear and convincing evidence that his substance abuse problems are under control and that they're likely to remain under control. His graduation from the treatment court program is evidence to support that conclusion. So is the excellent prognosis from a substance abuse professional. And so are the letters that he submitted. So is the fact that he was still engaged in some counseling through the VA. So I think because of that, the hearing officer's decision was not supported by competent material, substantial evidence on the whole record, and was therefore an abuse of discretion to deny Mr. Szymanski full driving privileges. So I would grant the appeal and sign the order directing the Secretary of State to restore those privileges.
Thank you, Your Honor. Thank you.
So you'll want to prepare the order, Mr. Kukuski, and secure Mr. Juliet's approval as to form.
I was just going to ask that, Your Honor. I will get that over to Mr. Juliet right away.
Thanks.
Thank
All right,
you.
I do see the prison and Mr. Voss. All right, Ms. Mahar, can you hear us fine?
Yeah.
Okay. All right, Mr. Voss, we've got Ms. Mahar here zooming in. Let us know at any time if you need a breakout session with your client. This is a continuation on a motion to withdraw a plea in People v. Mahar, file 23-6609. We've got Mr. Juliet for the people, Mr. Voss for the defense. And this is sort of an interim hearing that I had requested for some additional briefing. Ms. Mahar argues that her trial counsel was ineffective for failing to challenge the search. I have expressed on this record some concerns I do have about that search, but I wondered whether Ms. Mahar had standing to challenge that search. I invited additional briefing. I received it from both sides and had a chance to review it. So, Mr. Voss, I guess I'd first take your argument as to whether Ms. Mahar has standing.
Thank you, Your Honor. And of course, I would incorporate the contents of my brief. I've had a chance to read the prosecutor's brief, and he asked this court to apply the reasoning that's set forth in a First Federal Circuit decision, a 2014 decision of the U.S. versus Almeida, where the court found that the non-owner of the vehicle, defendant driver there, did not have standing to challenge the search for reasons which included, significantly apparently, that defendant couldn't really show any, they said, quote, pattern of repeated use and control of the vehicle, and therefore his use of the vehicle was only temporary. And the prosecutor would like the court, Your Honor, to add that requirement to whatever the court said in United States versus Byrd, which is a binding Supreme Court precedent case that I've cited in support of our position that my client does have standing. And you'll notice that the court in Byrd did not find dispositive, or I don't think they even discussed whether the defendant the non-owner driver of the vehicle there had any history of use of the vehicle. Also, that the court may have noticed that I attached my brief, an unpublished decision, People versus Thurman, apparently without ever referring to it in my brief. I'd like to say that's a trendy new briefing tactic, but it's not. I simply failed to note that that was the only, as I think both the prosecutor and I have noted, I couldn't find any recent published decisions in Michigan. That is the only recent unpublished decision I could find with a similar fact pattern. When I say similar fact pattern, I mean a driver of the vehicle is not the owner. And in that case, the court said, no, that non-owner defendant did not have standing to challenge the search, but they did not even discuss whether there was any history of use. They said rather that defendant, the vehicle was not registered to that defendant. That defendant did not even have any driving privileges. And that it was unclear on the record whether he had permission from anybody to drive the vehicle. Unlike the case before the court where we're claiming, well, I think it's undisputed, Ms. Maher had valid driving privileges, albeit not on her, and permission from the passenger. Now, the prosecutor makes a point in his brief. I think, well, we don't even know if the owner of the vehicle here gave permission to the passenger to give permission to Ms. Maher to drive the vehicle. I don't think that's relevant to a Fourth Amendment analysis, just as the court found in the cases involving rental cars. It didn't matter that the rental car company who owned the car would say that person driving the car never had authorization from us to drive the vehicle. The court found that not to be relevant. There may be some civil wrongs and some civil penalties associated with here. In our case, there was nothing unlawful. Nobody claimed the vehicle to be stolen by Ms. Maher or by the passenger. She had valid driving privileges, and there was nothing unlawful about her driving the vehicle. Finally, I would notice lastly and coincidentally that the court in Byrd actually raised the same example I think that Your Honor did at the first hearing, where the court in Byrd said that there may be, quote, countless innocuous reasons why an unauthorized driver might get behind the wheel of a rental car and drive it, such as the renter becomes drowsy and they both decide it's safer for the friend to drive. The court recognized this constitutes a breach, perhaps a serious one of the rental agreement, but the government failed to explain what bearing this breach of contract standing alone has on expectations of privacy in the car. And I seem to recall the court raised that very example at our last hearing. So I think because my client had lawful possession and control of the vehicle, then under the Byrd case, she has standing. Thank you.
All right, thank you. Mr. Julia?
Thank you. Well, this is one of the few instances in which a prosecutor doesn't have the burden of showing anything. It's the defendant's burden to show by preponderance of the evidence that she does have standing. Of course, I'm not going to go too deep into the Byrd case, but that dealt with a rental agreement and a person who wasn't on the rental agreement operating the vehicle. That's not what we have here. We have somebody with minimal to no connections to this vehicle operating the vehicle. The only evidence on this record is that she used the vehicle to conduct a methamphetamine sale in Sault Ste. Marie earlier in the day, and that she was stopped with apparently the co-defendant, who apparently had permission from the true owner to operate the vehicle. I think that is far too remote and far too suspect to say that the defendant has standing under the Fourth Amendment. I'll leave it at that. Thank you.
Thank you. Any rebuttal argument, Mr. Voss?
Well, just again, when he says there was no minimal to no connections to the vehicle, I guess I'm not. I mean, that's a good point, but I'm not seeing that requirement when we read Byrd or even Thurman. They're just talking about that at the time, did the person have lawful possession and control of the vehicle? And so if that's all that's needed, then that's what we have here. Then I don't know that the court can even consider what her history of use of the vehicle was.
All right, thank you. Well, in this case, Ms. Maher is seeking to withdraw her plea, arguing that her trial counsel was ineffective for failing to challenge the search of the vehicle, which led to the substances for which she was convicted of possessing and is now serving a sentence. And one of the things we first have to establish, and she has to establish that trial counsel was deficient in his performance and that prejudiced her. And part of that is she has to demonstrate that she would have prevailed on a motion to suppress And first off, does she have standing to challenge that search since she was not the owner of the vehicle? And the issue, we all call it standing, but I think there's some of the recent cases like Meade out of the Michigan Supreme Court remind us it's not really a standing question. It's whether they have a reasonable expectation of privacy. But so the question is whether Ms. Mahar had a reasonable expectation of privacy in the item or place to be searched. Did she have an actual expectation of privacy, and a society prepared to recognize that exception as a reasonable, that expectation as a reasonable one? The defense relies on the U.S. Supreme Court case, the Byrd case in 2018. In that case, the driver of the rental car was the sole occupant of that car, was not the listed driver, but was driving it with permission of the person who'd rented it, and driving it from New Jersey to Pennsylvania. And the holding there was that the mere fact that a driver in lawful possession or control of a rental car is not listed on the rental agreement will not defeat his otherwise reasonable expectation of privacy. Some of the hypotheticals discussed in that case notwithstanding, the holding was simply that. And some of the examples discussed in Byrd may be dicta as well. That Byrd involved the sole occupant of a vehicle driving the vehicle with permission from one state to another state, and saying just because he's not on the rental agreement doesn't undo his otherwise reasonable expectation of privacy. I think clearly somebody driving the vehicle by themselves from one state to another may well have an expectation of privacy in that vehicle that they're driving on that road trip. So after Byrd, there's some basic principles that are, I guess the best I could say is mostly clear. An owner of a car has a reasonable expectation of privacy. A non-owner driving a car alone, they're the sole occupant, they're driving it with the permission of the owner, would have a reasonable expectation of privacy. A non-owner passenger would not have a reasonable expectation of privacy in that car being driven by the owner, except as to their personal effects like the backpack. That's the Meade case from the Michigan Supreme Court. But what about what we have here? A non-owner driving the car with the owner present as a passenger. That's about as clear as mud. And here it's even more attenuated because the passenger wasn't the owner, but was in turn in possession of the car with permission of the owner. So perhaps the passenger, Mr. Kreider, had a reasonable expectation of privacy in the car. I don't know, but we certainly don't have to decide that today. The prosecutor relies on the Almeida case out of the First Circuit. The defense correctly notes that predates Byrd, but I don't think it conflicts with Byrd. In Almeida, the First Circuit, although that's not binding, I do find it to be well-reasoned and persuasive, but there's no bright line rule. Instead, you have to consider a bunch of factors, and they outline them. Ownership, possession, or control, historical use of the property searched for the thing seized, ability to regulate access, totality of the circumstances, the existence or non-existence of a subjective and anticipation of privacy. And they said, quote, "We look in short to whether or not the individual thought of the place or the article as a private one and treated it as such." I don't think that's inconsistent with Byrd, because Byrd says the fact you're not on the rental agreement doesn't defeat an otherwise reasonable expectation of privacy. There still has to be an expectation of privacy that is subjective to the person and that society treats as reasonable. And in Almeida, the defendant was the driver with the owner as a passenger, and then they switched seats. But where the defendant didn't own the vehicle and didn't show a pattern of repeated use or control over it, and the possession was only casual or temporary, the defendant in Almeida did not establish that they had a reasonable expectation of privacy in it. This case is much more like Almeida than Byrd. Here, the defendant was driving, but the passenger was the one who borrowed the car. Defendant was in the car with the passenger only for a single day's drug activities. And this, I think, is an important fact as well pointed out by the people. When the police asked the defendant for consent to search, she didn't say, "Get lost." She said, "Well, it's not my car, so I can't consent." That doesn't show that she treated the vehicle as her own private space. So I think under these facts, the defendant did not have a reasonable expectation of privacy in the vehicle to be searched. that her passenger had borrowed from the owner. Therefore, Ms. Mahar's trial counsel was not ineffective for failing to challenge the search. And for that reason, I would deny Ms. Mahar's motion to withdraw the plea. Mr. Voss, this is a super fascinating issue, so I'm sure you'll present an order to me denying your motion, seek review of that decision, and I'll look forward to the outcome of that review with anticipation.
Will do, Your Honor. Thank you.
Thank you. Do you want a breakout room with Ms. Mahar to talk about what happens next or no?
Sure, that'd be good. Thank you. Appreciate that.
Okay. All right, Ms. Mahar, I'm going to create a breakout room for you to talk with your lawyer. And when you're done, you don't have to come back to the meeting. You'll be all set.
That one right there is one of those cases that sets a precedent. And it's going to create kind of a standard to go by for that instance. And you can tell that he's had experience with that attorney. That was not a public defender. That was a retained counsel. And, the judge is like, I know you're going to write up a a briefing on this, and I'm looking forward to it. I have a feeling that attorney is probably going to, attempt to take it even higher than Judge Gauthier. Possibly. Depends on how much mommy and daddy paid for him. I know I promised Auntie M some church court the other day. Well, not specifically Auntie M, but I did mention church court. And there's at least one, maybe a couple more on it that I really liked. So I'm going to put that on. I don't know if we'll get through the whole thing because it's kind of long, but I always put the best one at the front for church court. Yes, Yvonne, my love. He is a very, he considers all aspects of the case. He's a very intelligent, and he's also a highly compassionate judge.
Okay, we have Mr. Perez for a change of plea.
Mr. Perez, okay, we'll start with that. Richard Perez, 2 cases, 4A0281821 and CB0101264. Mr. Perez, good afternoon, sir. Or morning, sorry.
Hello.
All right. We're here for pretrial today. It does look like there's actually a change of plea, though, so I just have some questions I need to ask you, Mr. Perez, about this guilty plea statement. So, it is to several counts. It looks like count 1 is protection order violation. I just need to double check. These are all listed as DV, but the DV box isn't checked on any of these. Is that intentional?
They should have been DV, Your Honor.
Okay. Mr. Perez, when you went over the guilty plea statement with your attorney, were you aware that these are all domestic violence charges?
Yeah, I just got told just now.
Okay. So, Mr. Gardner, is it fine with you if I check the DV box?
If Mr. Perez is aware, that's what we're doing, yes.
Okay. All right, so Mr. Perez, count 1 is protection order violation, domestic violence. Count 2 is going to be protection order violation, domestic violence, and then count 3 is assault in the 4th degree, domestic violence. Pursuant to those guilty pleas, the city is moving to dismiss numerous other counts. It looks like 1, 2, 3, 4, 5 counts of protection order violation, domestic violence would be dismissed pursuant to those guilty pleas. Have you in fact had the opportunity then to review this document with your attorney?
Yeah.
All right, do you have any questions about it for me at this time, Mr. Perez?
No.
All right, on the defendant's signature line, I do see a signature. Did you sign that document electronically, sir?
Yep.
All right, and do you understand, Mr. Perez, that by pleading guilty to these charges, you'd be waiving your constitutional rights, which does include the right to a jury trial and the right to remain silent?
Yep.
All right, we're going to take a look at the recommendation here. count one, that's first counter protection order violation. It says 364 days, suspending 289. I'm not good at fast math, so let's see what that is. That's 75 days on count one. Credit for any time already served towards that. Fine, $5,000, suspending $48.50. That's a $150 fine. It says suspended all for a period of 24 months probation. We will get to those probation conditions in just a moment. Count two says 364, suspending 264, so that is 100 days there. $5,000 fine, suspending $48.50. That is again a $150 fine and 24 months of probation. Count three also says 364, suspending 264, so 100 days there. $5,000 fine, suspending $48.50. That is a $150 fine. And count three says 60 months of probation, so that's 5 years of probation. The total then would be 275 days between all three counts combined, a $450 fine. 60 months of probation total. On that probation, it says obtain and complete a drug and alcohol evaluation, comply with the recommended treatment, complete a domestic violence evaluation, comply with the recommended treatment. There is a request for a post-conviction no contact order. As there is a request for an drug and alcohol evaluation, you would also be subject to testing, so that involves typically urinalysis. It can also be a breath test, in order not to possess or consume intoxicants, controlled substances without a prescription, and marijuana while on probation. I do need to ask, it does say the EHM box is checked. Is there some sort of agreement to release Mr. Perez to EHM?
Not that the city is aware of.
Okay. And then lastly, it does say, of course, there's no firearms, so as a result of these convictions, Mr. Perez, you would be prohibited from owning, possessing, controlling firearms until that right is restored to you by a court of law. There additionally would be a $115 domestic violence fee that's required by statute, so that would be imposed, as well as a $100 monthly probation monitoring fee. So it looks like that is the agreement here. Obviously, it's fairly substantial. Do you have any questions about that recommendation, sir?
No, I guess not. Like you said, it's pretty substantial.
Okay. I have a few more
I just
questions.
would like.
Sorry, go ahead. I didn't mean to interrupt you.
I just never understood why it was so much.
Okay. I have a few more questions for you. If you need an additional moment to speak with your attorney after we get through this, I will certainly be happy to let you have that moment. But what I'm going to do, I'm going to finish asking my questions, and then we'll see how you wish to proceed here today, sir. So that is the recommendation. As far as what the recommendation is, I just want to be clear, you do understand what it is?
Yes, I do.
Okay.
275 days, right?
Yes, that's correct. And
Okay.
the
All
probation.
Right. Okay.
Okay, and do you understand, Mr. Perez, that the court is not required to follow this recommendation and could sentence you anywhere up to the maximum penalty on all three of these?
Yes, I do.
All right, other than this recommendation, sir, has anyone promised you anything or threatened you in any way in order to get you to plead to these charges?
No.
Okay, are you in fact doing this today on your own free will?
Yeah.
Okay. Lastly, are you also aware that if you're not a United States citizen, conviction of these crimes could carry negative immigration consequences?
Yes.
All right, I have one just extra question for you, Mr. Perez. You did indicate that you're not sure why the recommendation is so high. I can't tell you why a recommendation was made. That's not the court's part. All I can ask, do you need additional time to talk to your attorney about the recommendation, or are you comfortable proceeding at this time?
Well, I have to take it now because the prosecutor said if I don't, he's going to turn it into felonies. So in order for me to avoid that, I have to take it now.
Okay, all I want to make sure, and I just want to make the record crystal clear, are you entering into this plea because today this is what you want to do?
Yeah.
That's kind of how a plea deal works. You have this charge, and the prosecutor's offering you this charge. If you don't take this charge, the prosecutor goes for this charge. It's not that he's turning it into anything. It already was that. And he's giving you some grace by reducing it.
Okay.
Yes.
Okay. All right, Mr. Perez, I'm comfortable moving forward then. Mr. Gardner, are you satisfied on your end that Mr. Perez is making this change of plea freely, voluntarily, and intelligently with full knowledge of the consequences?
That's based on Mr. Power's representations, yes.
Okay. All right, Mr. Perez, I have to go through these one at a time. So on count one, under cause number CB0101264 to the charge of protection order violation, domestic violence, how do you wish to plead today, sir?
Guilty.
All right, on count two, under the same cause number, CB0101264, also protection order violation, domestic violence, how do you wish to plead today?
Guilty.
And on count three, cause number 4A0281821, charge of assault in the 4th degree, domestic violence, how do you wish to plead today, sir?
Guilty.
All right, thank you. And counsel, I'll swear you in. Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do, Your Honor.
All right, go ahead, Mr. Deplorable.
Your Honor, I'm reading for the probable cause affidavit of Officer Mara. It's dated April 9th of 2024. On April 9th of 2024 at approximately 2013 hours, Pamela Fox Perez called 911 advising she had been assaulted by her husband, Richard Perez, at their residence on East Sunset Drive in the city of Bellingham, Washington. Bellingham police officers arrived on scene where Pamela Fox Perez disclosed she got into an argument with Richard Perez inside the kitchen area of their home. Richard Perez was calling her various names in an aggressive manner. Pamela Fox Perez told Richard Perez to go outside because she felt threatened by Mr. Perez and did not want things to escalate. Mr. Perez was highly intoxicated at the time and had made threats to kill Pamela Fox Perez in the past. Pamela Fox Perez said Richard Perez then spit on her several times while calling her names in the kitchen area. Richard Perez then grabbed Pamela Fox Perez's right arm and pulled Pamela Fox Perez forward aggressively. Pamela Fox Perez was already standing in a stable position and did not fall. She did not have markings from this altercation but complained of pain in her arm. Pamela Fox Perez called 911 immediately after this occurred and Richard Perez went outside to the back shed. To include, Pamela Fox Perez had dried spit on her shirt and appeared in distress. She believed Richard Perez would further assault her if officers did not respond. Pamela Fox Perez's son, Nathan Walteri, and his sister, Michelle Fox, heard the interaction from downstairs. Michelle Fox advised she believed Richard Perez and Pamela Fox Perez were in the kitchen area due to the sound of their voices. Michelle Fox heard Richard Perez yelling and calling Pamela Fox Perez names and it appeared heated, so she stayed downstairs. Michelle Fox heard what she described to be spitting noises, and Pamela Fox Perez yelled for Richard Perez to stop spitting on her. Mr. Walteri believed Richard Perez spit on Pamela Fox Perez because he heard spitting noises as well as heard Pamela Fox Perez yelling for him to stop. Richard Perez was read his constitutional rights, at which time he disclosed to understand and wanted to speak with the officers. Mr. Perez first denied touching Pamela Fox Perez or spitting on her. However, after Richard Perez was placed in handcuffs, he said something similar to, "It just came out of my mouth when we were talking." Based on the above facts, probable cause existed for Richard Perez for assault with 4th degree domestic violence.
All right, and then as for the VNCOs?
And for this one, Your Honor, I'm reading from the report of Officer Mitchelson, dated April 17th, 2024. On April 17th, 2024, I was contacted by the City of Bellingham attorney, Owen Kilfoyle, who reported that Pamela Fox Perez had left a voicemail message at the Bellingham Municipal Court complaining that Richard Perez was calling her from the jail in violation of the NCO. Kilfoyle sent me the voicemail message, which I reviewed. The message was left for DV advocate Cheryl Cartwright. Miss Pamela Fox Perez stated that Richard Perez keeps calling her from the jail. Pamela Fox Perez said that she answered one of his calls and reminded him not to contact her due to the no contact order. Pamela Fox Perez says that Richard Perez keeps calling her. I logged into the Whatcom County jail phone system and researched Richard Perez's call history. The information generated showed that Richard Perez called Pamela Fox Perez's number 3 times on April 14th, 2024, twice on April 15th, 2024, twice on April 16th, 2024. It appears there was only one actual conversation which took place on April 14th, 2024. as Pamela Fox Perez stated in her voice message. I reviewed that conversation and listened to Richard Perez and Pamela Fox Perez talk to each other. Richard Perez asked Pamela Fox Perez to bring him his cell phone and put it in his property box at the jail. Pamela Fox Perez does remind Richard Perez there is no contact order. I have downloaded the recorded phone call and saved it in Axon as evidence. Richard Perez was arrested for assault in the 4th degree DV on April 9th, 2024 and booked into the jail. The victim in that case is Pamela Fox Perez. On April 10th, 2024, a pretrial domestic violence no contact order was served on Richard Perez. The order states in part that Richard Perez may not contact Pamela Fox Perez directly, indirectly, in person, or through others by phone, mail, or electronic means. The order is valid and does not expire until April 10th of 2099. On April 18th, I spoke with Pamela Fox Perez by phone regarding this investigation. Pamela Fox Perez confirmed she answered the first time Richard Perez called her from the jail because she thought he forgot there was a no contact order. Pamela Fox Perez says she reminded him about the order and said she would try to get his phone to him. This was consistent with what I heard on the recorded jail phone call referenced above. Pamela Fox Perez said that Richard Perez had continued to call after that, but she had not answered. Based on the facts of this investigation, probable cause exists to arrest Richard Perez for RCW 7.105.450, violation of a domestic violence no contact order, 7 counts.
Thank you. Okay. Based on that sworn testimony, court accepts your guilty pleas, Mr. Perez, on all 3 counts, finding that they were made knowingly, voluntarily, and intelligently with full knowledge of the consequences. There is a factual basis to support all 3 guilty pleas. The court would find that all elements of all 3 counts have been satisfied beyond a reasonable doubt. The charges have been pled and proven. The court has now entered findings of guilt on those 3 charges. Mr. Kilfoyle, go ahead if you're ready on sentencing.
And Your Honor, at this time, we're going to be asking to set the sentencing over to Friday morning. We didn't have confirmation that this was actually going to resolve today, so we just want to have the victim have an opportunity to provide any input for the sentencing here. Our office has been in good communication. I do expect that we will have some sort of input, or she will be present to provide her statement at that time. Considering the amount of time that the defendant is facing, the setting over to Friday in custody shouldn't be any sort of an issue. That would be the city's request.
Okay. See, he has been in custody for a pretty significant period as well. I think it's been since April. Mr. Gardner, any objection to the 2 days?
I would just defer to Mr. Perez. Mr. Perez, do you have any problem setting this over to finish sentencing on Friday?
Well, you guys can do it without me, can't you?
No.
I don't need to get drug all the way over here.
Unfortunately, no, sir. You need to be present for sentencing. The alleged victim, or victim at this point, as there has been a finding of guilt, has the right under Washington law to be present at sentencing, and it sounds like the city didn't have an opportunity to bring them or let them know that this was occurring today. So,
Well, they should have, in my opinion. They should be ready. I'm here ready. They should have been ready and had whatever they're going to do, because I came here to be sentenced and done.
So,
I'm not. I don't want to come back here again.
Mr. Perez, it sounds like there was no confirmation that this was actually resolving here today. So,
Absolutely not.
So I'll note your objection, Mr. Perez, but I have to follow the law here in Washington and give the victim the opportunity to be heard. So I am going to grant the city's request to set this over to Friday morning. That's October 25th at 8:30 for sentencing. So today we are not moving forward with sentencing.
The only other thing the city would add is I am uploading the post-conviction no contact order now, so that the court can review it with the defendant.
All right, I'll be just a minute. So I'm entering the findings of guilt, but I'm not obviously doing the sentencing here. Mr. Kilfoyle, just to maybe make it cleaner on Friday, are you fine moving forward with the other dismissals today?
I'm fine with doing the dismissals today. The city would move to dismiss 5 of the VNCO counts. At this time, the domestic violence charges, we would be doing that with prejudice.
All right, any objection there, Mr. Gardner?
No objection.
City's motions granted. 5 counts protection order violation under the 264 cause number are dismissed with prejudice. It is going to take me a minute to get that entered on the order here. Okay, so the last thing I'm just doing on the order here is obviously putting the sentencing date on there. So October 25th, 8:30. Counsel, if you don't mind signing off on the judgment and sentence in just a moment, because it is effectively our continuance here today. I'll get out of the document.
I'm signing the judgment and sentence?
Yes, because if you look at the top of the JNS there, I have sentencing set over to October
Okay.
25th, so it's basically our continuance. The only other thing on the JNS at this time is the guilty findings and the dismissals on the other BNCOs, and we'll enter a fresh JNS on Friday with obviously all the other relevant information.
Mr. Perez, can I sign your signature on here? Just an acknowledgement that we're setting it over until Friday.
Just to be clear, Mr. Perez, it's not that you're in agreement with it. I've noted
No.
your objection for the record.
You're just acknowledging that the court's moved your sentencing hearing to Friday.
Yeah, well, nothing I can do about it.
That is close to, yeah, you can object, and I think you've already done that.
It don't
So
matter.
is it all right if I sign that you've been told that your sentencing is moved to Friday?
Yeah,
Mr. Kilpo, can you sign off on the guilty?
pretty obvious.
As well.
And that NCO is ready, Your Honor. It's the one that has the 2 case numbers.
All right.
We could probably do that on Friday too, couldn't we? If we want to do it now, though, we can do it now.
Yeah, let's get this done.
Okay. We can't complete the process.
Today, what I'm
Mr.
going to do,
Perez.
Mr. Perez, is we are going to go through the no contact order right now. I see 2 loaded up, Mr. Kilfo. Are we entering 2 separate ones?
No, I saw that there was one that was uploaded on 1 case number. The one I filled out has both case numbers.
Okay, all right. So just the one with both case numbers.
Correct,
Okay.
Your Honor.
So, Mr. Perez, the order does protect Pamela Fox Perez. It does prohibit you from doing a number of things. Do not cause, attempt, or threaten to cause bodily injury. This does include any type of assault, harass, stalk, or keep under surveillance the protected person. You are simply to have no contact with them at this point. That does include face-to-face through a third party. Electronic and written contact are included, so texting, phone calls, emails, social media. Do not knowingly enter, remain, or come within 1,000 feet of the protected person's residence, school, workplace, vehicle, or wherever they might be. These convictions do prohibit you from owning, possessing, controlling a firearm. That is noted on this order here, and you would have to immediately surrender any firearms or the other dangerous weapons to the Bellingham Police Department. This, at this time, is going to be a 5-year order, so it will remain in place until this date, which is October 23rd of 2029. Additionally, sir, I just need to let you know that as a result of these 2 convictions, any subsequent no contact order violations could and likely would be filed as felonies, just so you are aware. So it is very important that you follow this no contact order. Do you have any questions about that order, Mr. Perez?
Well, it's hard to measure 1,000 freaking yards or whatever if I see somebody somewhere. I mean, that's just crazy. If I'm in a store trying to buy groceries and that person suddenly is in that store, I'm supposed to just drop everything and run?
That is essentially correct. So the order includes, the order, Mr. Perez, is a knowledge order. So if you do not know that you are within 1,000 feet of the protected party, that's not a violation of the order. But if you see and become aware that you're within 1,000 feet of the party, then your obligation under the order would be to leave. That's how that works.
All right.
And again, can I sign your acknowledgement? You understand what the order prohibits? Can I sign that you've been told of those conditions and that you understand them?
Yep.
Okay, Mr. Perez, I understand your frustration, sir, but I appreciate your patience. We're going to see you on Friday morning, and we will get this resolved once and for all for you, sir. Thank you.
Yeah.
And I did check Friday, and I don't know if he was released or if his court date got reset or what happened, but he wasn't on Friday's docket. I'm sorry.
All right, we'll go ahead then and call Rebecca Trot, cause number 3A0559126. This is on for a pretrial, and it looks like it is a warrant return. You have a new one? Thank you, Mr. Hooper. That's okay. Thank you. All right, Ms. Trot, good morning, ma'am.
Dude, I can't that one. Please, I need the chips.
All right, so I need to pull up an order on review here.
Take your hands out of your shirt.
See.
crazy.
There just isn't an order uploaded, so I'm throwing in an order on review right now, and she'll show up on the screen. All right, Ms. Trot, good morning, ma'am. We are on the record here in Bellingham. This is on after a warrant return, so we have several things we need to address. We will need to address the conditions, as this was a priority hold, so we'll need to set bail at this point. And then, Mr. Garner, we do have an amended violation from probation. It looks like 3 alleged violations on pretrial. Are you able to admit or deny those today?
I can't. I haven't had any contact with Ms. Trot, so.
Okay, has Ms. Trot talked to counsel?
I don't know that they discussed the probation violations.
Okay, so we'll enter denials here today on those.
Yeah.
Okay, Ms. Trot, as for the pretrial violations, court is going to enter denials on your behalf as to all 3 of them. It sounds like you have not had the opportunity to discuss those with counsel. We do nevertheless need to address release with that priority hold bench warrant being served. So Mr. Kilfoyle or Mr. Hooper, would the city or probation like to be heard on conditions?
Your Honor, at this time, the city would be asking for $4,000 cash at court-approved performance bond. As far as the pretrial release conditions, probation, monitoring, we would be asking that if the defendant does post, that the defendant report immediately to probation for an intake appointment. I do believe that UAs need to be set up at this time. I note for the record, the defendant was just picked up. The number 3 allegation at this time is a new charge out of Ferndale Municipal Court for protection order violation, domestic violence. Considering that our underlying cases in assault 4th-degree domestic violence and an obstructing charge, and considering the FTA on our case was from back in March, over 6 months ago, I think that the bail the city is asking for is completely appropriate.
So I'm just checking. So the protection order violation, I see that out of Ferndale. Is that based on this order? And it looks like this is the only active
that's
order.
the case.
That is correct, Your Honor.
Okay. All right. All right, Mr. Hooper, did probation.
I'm sorry, I can't hear you. There's yelling going on in the hallway.
All right, we'll sit tight for just a moment, Ms. Trot, until it quiets down.
Okay, thank you. But also, in my defense, sir, I have a lot of health problems. I have congestive heart failure. I have tumors all over my thyroid, my adrenal glands, pulmonary tumors. I have a lot of health problems, and I had COVID at the time I was supposed to go to court, and I did show up and talk to the district attorney, and he told me to contact him when I was feeling better and able to come in. But the problem is I haven't been feeling better. I've been over the COVID, but I've been so sick I haven't even been able to make it to all my doctor appointments. My son Cottrell has been my caretaker, and without his help, things have been horrible, even worse. I'm getting worse, and I need to go in. I need to see my doctor. I need to go in and see my cardiac specialist as well.
Okay.
I'm sick.
So, Ms.
I understand that she's going through a lot and has a lot of health problems, but Control is the party with the protective order that she's supposed to have no contact with.
I'm sick, that's all.
Okay, I'm gonna hear from your attorney as well. Thank you for adding that
I don't
here.
have an attorney yet.
We have an
I
attorney here.
haven't spoken with one yet.
We have an attorney here in court who's going to speak in just a moment. I am going to hear from probation. Did probation wish to be heard, Mr. Hooper? Okay. So I'm just reviewing the conditions, first of all, that were ordered at arraignment. It looks like it obviously was a PR at arraignment. And it says, so there was pretrial supervision with testing. And it looks like that's essentially it. Okay. All right, Mr. Gardner, would defense like to be heard on conditions here today?
We would. We have no problem with maintaining any other previously imposed release conditions. We don't know the factual basis of the new criminal law violation. It sounds like that may be a caregiver. Is that the protected party? Is the protected party, do you have the no contact order with your son? Ms. Trot, who's the protected party?
I'm sorry, I don't understand the question.
Who is the person you're not supposed to have contact with?
My son.
Okay, and he's been providing care for you, correct? Because of your health problems?
Yes, he's been keeping me alive.
Yes, that's my understanding. And so I think that there's a couple of things here. One is that we have this charge This is a first domestic violence charge. And then
There was no domestic violence.
this is the charge is domestic violence, Ms. Trot.
There was no domestic
and then there's
violence.
been, since that occurred, Your Honor, there hasn't been any other issue until this Ferndale charge. There is my
It's
understanding.
trespassing.
There's a $2,000 appearance bond posted on that. Given Ms. Trot's health conditions and the fact that there are some mitigating circumstances regarding the contact that she had with a protected party due to necessity to address those health conditions, we would ask that the court impose $200 cash bail rather than $1,000.
Here's my only thought, and I don't necessarily disagree with you. Here's my only concern here. Essentially, it sounds like there's not. It sounds like the no contact order is going to continue to be violated.
And we'll have to address that. I mean, we'll have to bring that into court if it's appropriate to do a modification of the no contact order and address that. So, Ms. Trot, you understand that there's still a no contact order prohibiting contact between you and your son. So until that can be brought back into court and addressed, that will have to be, you'll have to not have contact with your son.
Okay. Right now, though, they've denied me my medication. I mean, everything. They're going to kill me.
Okay. Here's where I'm at, Ms. Trot. Your attorney makes a very good point today. I'm going to set the bail at the $200 that's been requested. I'll note any objection from the city. Court does find, I think, obviously the new charges, clearly just with it being filed, that would be a violation of pretrial release conditions here. I think the $200 is appropriate. Pretrial supervision remains. That doesn't change. That's already been ordered at the arraignment. If you post the $200, you will have to report to pretrial supervision. That is, the probation department is located on the 4th floor of the county courthouse. That is the building right next to the jail, and their address will be on this order. So you'll have to head right on over there if you post the $200. And the $200 essentially, ma'am, matches the amount that was posted in Ferndale. So that is, I think, a reasonable amount here based on the fact that there is a new charge and this warrant has been outstanding since, I believe, March or April of this year. It's been for at least 6 months. So that's going to be the court's order at this time. What I need to make crystal clear here, just like your attorney this morning said, our no contact order is still in place. If you violate it again, there's going to be new criminal charges. Realistically, this court and likely another court, if it is in another jurisdiction, will impose increased bail. I don't see any other way around that. So you need to follow the no contact order. You cannot have contact with the protected party at this time, ma'am.
We need to get the no contact order dropped. How do we do that?
We can't do that today, Ms. Trot. So what the court is telling you is that until we have an opportunity to set a hearing to address that order is still in effect and you need to abide by it, or else you would be subject to a new charge.
All right, I'll be just a minute with the order. Counsel, we will need to set both in and out of custody dates at this time until the bail is posted. Okay. How far out do you want to go in custody?
Let's go 2 weeks in custody.
Okay. So we'll set both the review on the pretrial violations and the actual pretrial on, is that November 7th?
Does that give us enough time to note up addressing the no contact order?
I think so, because we just need to follow, the 5-day court rule, give the city and the alleged victim an opportunity to respond. And so I think 10 court days.
My son is in jail right now. He's incarcerated. Control Trot is incarcerated at this time.
Okay.
How could I have contact with him? So you don't have to worry about me violating that no contact order because there's no possible way for me to have contact with them.
Well, that certainly is a factor in your favor, ma'am, which I think just supports the reasoning for setting the bail at a much lower amount. So,
as we learned with an earlier defendant, that may not stop you from making calls from the jail or for him to call you, or I mean, there are ways of violating the no contact order while he's incarcerated. So don't even pretend. Don't play that game.
That's what I'm going to go ahead and do. I'm just trying to fill out the order right now. Unfortunately, my system is not cooperating with me, so you'll have to wait just a moment. I'm trying to get this order completed. So that would be
I'd really like to get this thing dropped.
November 6th at 8:30
Also,
would be
I
the
don't really have a long to live. I don't have long to live.
Okay, I
You
understand
know,
that.
I'd like to see my son again before I die, and there was no violence between us.
Ma'am, I certainly understand your position. All I'm saying is that we have to go through the proper process to review a no contact order. Your attorney understands this. They're gonna get that process started, but we simply have rules to follow. It's a court. We have to follow the court rules.
So what we'll do, Ms. Trot, is that if you're still in custody in 2 weeks, we'll address the no contact order at that point in time. If you've been released, then we'll set up a hearing to address the no contact order. It looks like your son may have a no contact order where you're the protected party as well. So that would obviously have to be addressed as well. So we just can't address those issues right now. We have to set a hearing where the court can determine whether it's proper for either or both of those no contact orders to continue to be in effect.
Also, one other thing, they haven't even given me my phone call yet. I haven't been able to make a phone call since I've been arrested.
That's beyond the scope of what we're doing here in court this morning, ma'am, so.
It's a violation of my civil rights.
So, one moment, I'm just trying to finish up the order here. In custody, pretrial will be the same day at 11/6. We're just doing the review and the pretrial, both on that date. Out of custody, usually, obviously, we need a pretrial and an out of custody review. Would there be any objection to maybe setting them both to a Thursday? I guess it would be Thursday regardless.
It would be Thursday regardless.
Okay, so where are we going for Thursdays out of custody? Okay, 12/19 would be that out of custody date. Okay, there we go. I think I've got it all covered here on the order. Oh, and I'll get out of it real quick. I'm sorry, Mr. Gardner. Go ahead if you're able to sign.
All right, so essentially what we're doing, Ms. Trot, is we're setting your court date, your next court date if you're still in custody to November 6th in 2 weeks. And then the out of custody date is December
19th.
Is December 19th. Do I have your permission to sign? You're just acknowledging that you've been told that those are your next court dates.
Yes.
All right, thank you very much, Ms. Trot. Appreciate your time this morning, ma'am.
Thanks. Can you tell them to give me my phone call at least?
I can't order the jail necessarily to do anything in that regard, ma'am. If you need to make a phone call, just speak to one of the deputies.
Okay. Now you'd like me to leave?
Your hearing is concluded, ma'am. Thank you very much.
Thank you. Have a good day.
Yeah. If she's got a no contact order and her son has a no contact order, they've got some work ahead of them to get those rescinded. So I hope she's not dealing with the health issues to the extent that she says she is. I genuinely hope she was being hyperbolic, but I'm not sure either. Okay, and there is more to that, but it's nearly 12:30. I am getting extremely tired. I don't want to fall asleep while streaming. So I'm going to do that after I say goodnight. Thank you all for coming out and spending time with me. I can't tell you how much I needed this and how much I love you. For real. Thank you for finally showing up, Sir Philip. Sorry, I have to. I had to. Yeah, well, that's what happens when you start streaming at 11 p.m. or 11:45, as is too often the case. Yeah, it's 2:23 a.m. currently, and I've been live for 2 hours and 40 minutes. Yes, I love you all. Thank you for being here. All right. Be safe, be well, sleep sweet, and much love.